Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Charles Hatley with Malone Hatley PC, and this is our podcast, I Now Pronounce You Divorced. Today, we're going to talk about part 2 of depositions, what you can expect at a deposition, what you can expect to be asked at a deposition, and what you can expect your attorney to do while you're being asked questions at a deposition. So today, I'm joined by Rebecca and Dan. And Rebecca, my first question goes to you. When your clients are getting ready to be deposed, right, they're going to be the one asked question. How do you prepare them for how broad the subject matter can get and tell them not to get angry about it?
So the very common example that we give is you always want to answer the question that you're asked. Don't go beyond, right? If somebody asks you, do you know what time it is? The answer is either yes or no, right? The answer is not to tell them the time. Let them ask the next question. Let them get to the next thing that they're going for. And it's very difficult because you want to jump in and you want to give an explanation. You want to give more information. And they say that attorneys are actually the worst clients to have because we love to jump into that and like over explain and give the analysis and all of this other stuff. So that's really the simplest form, is just answer the question that you're asked. If you're asked a yes or no, you have to choose yes or no. And this gets to be one of the most infuriating things sometimes when you're in court and the client feels trapped. They want to give a yes, but, or they want to give a no, except type of an answer. And that's not what you're being asked. You have to answer the question that's being asked. And then your attorney can come in later and let you clarify and let you give that additional information. You know, earlier you were asked such and such, you answered yes. Can you further elaborate? Or can you explain the circumstances of that? Or something along those lines. So you'll get your chance. Your attorney's there to give you that chance to come back and save yourself or give that additional explanation. When you're being asked questions from the opposing side, you want to limit those answers. You want to keep them short, keep them direct, and keep them on point to exactly what's being asked of you. If your attorney jumps up and objects, that means stop talking, right? That means stop talking until we address the objection, and you might have to continue or not, but wait until you're instructed one way or another. Don't keep, spilling the beans. And then the objection is upheld, but the cat's already out of the bag, right? You've already given the answer. So those are some of the kind of the basic pointers. Depending on the specifics of your situation, you're going to probably know the pain points that the other side is going to go for, right? If the divorce case is based on adultery, they're probably going to ask you some questions about adultery. If there's been issues about custody, they're probably going to ask you about custody. And so your attorney can better tailor questions to really coach you and train you on what to expect and how to avoid getting heated or getting upset, and being successful in your deposition.
I love the example you gave. You got to answer the question that you're asked, right? And I always it's the same one I'm used. I would say, let me ask you a question. Do you know the time? Everybody goes, yeah, I think it's, 10:30 or whatever. And I'd be like, no, it's yes or no. And you're talking about these yes or no questions. I had an attorney in court one time, opposing counsel, walk somebody beautifully through a yes or no question. She was like, have you ever been drunk? Yes or no? Client said, well, yes. And have you ever drank to the point that you blacked out? Yes. And when you black out, do you remember everything that you do? No. So when you're blacked out and don't remember everything you do, could you have hit your wife? And of course, the question's objectionable for some other reasons, but I was like, that's a pretty good question. Because my client was like, well, yeah. I was like, oh, I objected. Please stop talking. But I was like, that's a pretty good question. So Dan, when you're in deposition in the last episode, you brought up that sometimes they get heated. How do you prepare your client to watch the other side get heated? And maybe they watch you get a little bit heated, but not for them to get heated. Tell them like, hey, look, it's mostly a show. You've got to don't react to my temperature. How do you do that?
carefully. It's a delicate line to walk because you want your clients to be involved. And you know there's a lot of emotions, but at the same time, if they're going to get excited in deposition, then it's going to further excite the other side. And then we may not get the responses that we want. They may shut down the other side. And so it all just goes back to preparing, as Rebecca was saying, making sure that they know how to answer the questions when they answer the question. I always advise my clients, before you answer, pause. Count to 5 in your head. It's going to feel like an eternity when you're going 1, 2, right? But you just want to pause and do that for all questions, and don't give any emotion. Just be as stoic as you can, because emotions may elicit other questions, and it's in a deposition. The judge can't see unless it's on video, and it may give the perception that something else is happening. And if you just answer the question, make sure that you're polite, be professional, no matter how inappropriate or personal the question is, make sure that you answer the question. And because at the end of the day, this is a family law case, divorce case, there's going to be some dirty laundry. And I really, when I meet with the clients, go over, okay, what could be embarrassing? What could potentially be our exposure here? But I also, when I prepare the clients, I'll bring in my paralegal with me. And this is when I was really litigating. We would have, it would be me, my paralegal, and the client. And then I would depose the client. The paralegal would depose the client, just so he or she could get used to questions being asked, how to answer those questions, which we never advise anyone to not tell the truth, but just make sure you're answering the question and just get that practice in, especially when there's uncomfortable ones. So you can kind of feel a little bit more comfortable when the question is asked, and to know what to be prepared for. And then we'll do cross-examination so they can be prepared as far as what does that look like. And then I'll have the paralegal ask the questions, and I'll redirect and kind of rehabilitate the client, just so they can see, okay, if I answer this question this way, then I know my attorney is going to come in and allow me the ability to explain. But that's also a slippery slope in the sense that we don't want too much explanation. So it's really kind of defining, all right, this is how you want to answer the question. Truthful, but you don't want to just go too far left, which then opens the door for additional questions. And it's always hard to explain to the client because they want to tell their side of the story. This is really what happened. But the more that you talk, the more questions that may be elicited from the other side, because now you're going down other avenues that maybe the other side didn't think of, and you're just opening up those doors that should really remain shut. And it's not our job to make sure the other side is asking the right question. It's just our job to protect you. You're spot on. When there's any objection, you stop talking. Or if you feel uncomfortable, you're not sure how to answer a question, maybe it's time for a break. We want to limit those because you don't want to be a pattern to where any uncomfortable questions asked, my clients say, oh, I need to take a break or something. But there is the ability to take a break and try to get some clarity so we can move forward. But in that preparation, we always advise the clients, it's going to get heated. It's inevitable. If you see me, the intonation of my voice maybe get a little bit raised or a little bit more calm, or it kind of ebb and flow, that's because we're leading the witness down a certain path. We're not engaging in any type of argumentative or combative discussion. It's just that we want to make sure that we're getting the answers that we want. Because sometimes, you are in these high conflict or stressful situations and you're nervous. And we want to try to break down those barriers for my client, but the other side may be nervous. And I may just allow the person just to talk until their attorney objects. I've been in a couple of depositions where I knew my client was thinking, why aren't you asking any questions? Well, it's because the other side is volunteering everything. I don't need to ask anything. As I just want the client to know, I may not ask them questions because we already have the answers that we want or we need. Or maybe I'm not asking a certain question, to Rebecca's point, because it isn't the gotcha moment. That's what we want to say for trial to use for impeachment purposes.
Mm-hmm. And it's hard to work with clients and say, look, I'm going to raise my voice and I may even appear angry, but I'm not. I may get frustrated when the other side pleads the fifth and I say, okay, well, you can't. So that means you did do it. But you don't need to match my energy. And one of the harder things that I have with clients is when they know that the other side has lied, right? So if the other side is, I'll use adultery because it's a pretty emotional issue. Like, hey, did you commit adultery? The other side says no. And, we've got the pictures, we have the video, we have everything that we need. How do you, Rebecca, convince your client to sit there and show no emotion and not jump up and be like, you lying bastard, I know you did it?
Yes, I unfortunately saw someone do this in court. He was testifying and he was trying to talk about why he needed to change custody, and he was, calm and cool and collected. And I guess she made a face at something that he said, and he completely exploded on the witness stand and screamed at her and said, "You are a dangerous person." And like, it was so off the rails. And everybody in the courtroom was like, and there was no coming back, right? Cat's out of the bag. Can't take that away. Judge saw everything. We know who the aggressor is. We know who the problem is in this situation. And then to come back and say, "Oh, and so I should have more custody because, like I'm so much better than her." It was a sight. And so that's the opposite of what you want to have happen. And I give that example a lot of the time when I'm talking to clients about how to prepare and what not to do and what we've seen. You have to go in and be prepared that they're not going to come in and say, "Everything's all my fault. I'm the worst person in the world." Of course, they're not going to come in the room and say that. And so you have to be prepared that they're going to say that you were the problem and that they, maybe did everything right, or that they're not really at fault for it. That's what they have to say, right? They're trying to protect their interests. They're trying to pursue their case the best that they can. So you're going to hear some things that you don't like. And I like to give them a notepad, give them a pen. If you need to write something down, if you want to draw something to my attention, do that. But don't say anything. Don't make expressions at the other side. Don't make faces at the other side. Just mind your business and write it down, and we'll talk about it later, right? I can do a lot more with the information after the fact than I can if you have some sort of explosion or some sort of outburst in the middle of the deposition. It's going to be really difficult to come back from that.
No, and you're nicer than I am with a full notepad. I give one piece of paper at a time.
One piece of paper.
Well, I told the clients, look, you can't write too much, man. And I used to tell them, like, if you write stuff, I'll miss things. Like you're writing so much and trying to get me to read it, I'll miss it. Mm-hmm. And it really became, I would say, look, I'll give you one piece of paper. When you fill that up, we'll talk about another piece of paper. And I would explain communication is key, right? So, Dan, one of, I think, the most obscure aspects of a deposition is what your attorney is supposed to do while you're being asked questions. So can you kind of walk us through when your client's being asked questions, what are you supposed to be doing during that time period?
Sure. One is listen and take notes. And I always have a pad of paper, not one sheet, but a pad of paper in front of me. So when I'm taking notes, I'm just writing down kind of certain answers, not taking really copious notes because you want to listen. To your point, you want to make sure that you're not missing anything. But I always advise the client, I may not object because it's a question I can ask you about later to rehabilitate or get further clarification. But just answer the questions no matter what the question is. That's why I always think just pausing is important because it gives me an opportunity. If I want to object, I can object. But answer the question and only answer the question that was asked. And then when it's the other side is done asking questions, then it's my turn to get clarification or to do some follow-up questions. Because I'm really mainly limited based upon the questions that are asked to my client. And I always want my client to know that because there are some times where the client's like, well, why didn't you ask me about this? Or why didn't we talk about this? Well, it's because I'm limited in scope as far as what I can really follow up on and ask you. Now, if I wanted to put you on the witness stand and do direct, that's entirely different. But this is a deposition. And so just kind of explaining the process to them and really give them the why. I agree with you. Communication isn't just communicating and returning phone calls or emails. It's giving the why so the clients can fully understand and maybe appreciate, but at least understand the purpose of what the depositions are, and that some of these questions are going to be, pretty bad in the sense that they're going to ask some embarrassing or maybe air some dirty laundry, but that doesn't mean your case is sunk. It's just the other side just trying to find out questions. And in some jurisdictions, and we've been talking about adultery, it doesn't matter. I know where I'm licensed at in two of the states, Illinois and Missouri, the courts really don't care if there's an affair. So the other side ask it. I mean, I'm going to object as to relevance. It's a moot point if you answer yes or no because the court doesn't care. Now, if it's the adulterous situation where there's kids involved and you're exposing the kids to bad situations, yes, of course, we're going to have discussions about that. Then that's relevant. Or if there's a dissipation of marital assets, then that may be relevant. But the fact just to show to the court, this person had an affair, it's irrelevant. And so I use that opportunity to allow the side to ask some irrelevant question because then it strengthens my position when I'm arguing for attorney's fees.
Yeah. And, one of for us, I tell people you're probably going to be a little bit shocked at how little I have to do when you're being asked questions, right? Even when I object, you're still supposed to answer, right? Like I'm just putting my objection on the record in some questions, right? Most of the questions I object to, like, I object to the form. I object to, like, if they hand an exhibit, I might object to the exhibit being hearsay, but you're still supposed to look at it. So Dan and Rebecca, I want to thank you for taking the time to talk to me about depositions. Depositions, I think, is a phenomenal tool. I know a lot of clients really don't like the cost of it, but like Dan said, most depositions end up saving money over the long run. It's an investment into your future. So if you or someone you know is going through the divorce process and you have questions, reach out to Malone Alley PC and see the difference that a partner can make for you. If you like this episode, please click like and subscribe, or leave comments and questions that you may have that we can answer later. Thank you.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.